A number of states have laws that revoke life insurance beneficiary designations in favor of former spouses. And it's a public policy consideration for some states in which the state presumes that someone does not want to have their ex-husband or ex-wife receive the life insurance beneficiary designations, and likely they just forgot to change the designation after the divorce. And I know that happens fairly often because I get a lot of those phone calls. So the way some of the states have handled that is to pass laws that automatically revoke such designations. In this video, we'll look at the law of Oklahoma. Oklahoma has a statute specifically dealing with this, but it's fairly broad, broader than a lot of other ones I see, in that it specifically applies to designations well beyond life insurance designations. The statute specifically mentions life insurance, but also annuities, retirement accounts, compensation agreements, CDs, security designations, and then also specifically other contracts designating a beneficiary of any right or property or money in the form of a death benefit. So essentially in Oklahoma, any sort of asset that passes upon someone's death, if it's in favor of a former spouse, the statute is generally going to revoke it. There are some exceptions, and Oklahoma has a number of exceptions in the statute. The first being is if the divorce or the annulment is vacated, if a judge should vacate the divorce for some reason, if they had gotten remarried, which makes sense. If the decree of divorce contains a provision expressing an intention contrary to the law, and that essentially says that the parties agree in the divorce, or the court orders that one spouse maintain coverage for the other spouse, particularly if it specifically designates the policy at issue, then that divorce decree can override the statute. Another exception is if the decedent makes the designation after the divorce, because that would express a clear intent by the decedent that they still want the former spouse to receive the life insurance benefits even after the divorce. Or if the decedent fills out another beneficiary designation after the divorce and the ex-spouse is still included, which is similar to the other exception, but it could be a situation where several people are designated and the spouse just happens to be one of them. Now, it's very important that you have an attorney who's experienced in evaluating these disputes to evaluate whether or not any of these exceptions apply, or, and this is extremely important, to evaluate whether or not federal law preempts the statute. In the case of many life insurance policies or retirement benefits, a federal law such as ERISA or FEGLI or VGLI will preempt state laws, and so the former spouse would still receive the benefits. It's very important that you have a lawyer who's experienced in evaluating these cases. Look at your situation up front.